Good morning. Hope you're doing well this morning.
Good, good.
Where would you like to start?
We can start with numbers 15 through 17, Mr. Collins. Awesome.
Yes, good morning, Mr. White. This will be a negotiated plea.
That's correct, Judge.
Thank you. Good morning, Mr. Collins. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? You have to speak up a bit for me.
Yes.
Thank you. You can place your hand down. Good morning, Miss Evans Battle.
Good morning, Your Honor. As to the first case, 6933E, 12 months served, 26 days, credit for time served, balance probated, complete the anti-theft course, a fine in the amount of $200, restitution in the amount of $200 to Sarthak Goel, spelled SARTHAKGOEL. No further contact with that person. Stay away from Club Veranda at 1140 Crescent Avenue Northeast. And as to the case ending in 2500E, loitering would be 12 months, serve 22 days, credit for time served, balance probated, complete an ADET, stay away from the Dollar Tree at 881 Peachtree Street, Atlanta. As to the obstruction, 12 months, served 22 days, credit for time served, $300 fine. And the state would move to null pros. The FTA asked that he stipulate to venue, identity, and a factual basis for the plea. Thank you.
Mr. White?
Yes, Your Honor, we do stipulate for the purpose of the plea. We would just ask that all fines be converted to community service. That'd be 50 hours community service by my math. Ask to waive the first 2 months of his probation fees and allows probation to terminate or go non-reporting once he completes all of his requirements.
Okay. Mr. Collins, it's my understanding that in case 23 CR 006933E, you wish to plead guilty to theft by taking, and in case 26 CR C 002500E, you wish to plead guilty to loitering and prowling and willful obstruction of law enforcement. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes. I have one question. I didn't understand. I didn't understand what you said like that. The FTA.
Oh, go ahead, Mr. White. You want to explain that to him?
Yes, from the earlier case that you missed court, it's called a failure to appear. They're going to dismiss that, so it's not a problem.
All right.
Okay. Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Collins. I will waive 2 months of the probation fees to help you get on your feet. I'll convert the fines to community service, and when you complete the term to the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't have to report to probation and pay those fees. Good luck to you, sir.
All right. Thank you.
Yes, sir.
All right. 22 through 24, Mr. Dewberry.
So, Your Honor.
Thank you. Good morning, Mr. Dewberry. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Yes, Ms. Evans-Bello.
Yes, as to the case ending in the 7242G, simple battery, it'll be 12 months, serve 183 days, credit for time served, balance probated, stay away from MARTA, no further contact with Rosalva Blanco, 12 weeks of anger management. As to the case ending, I have a case that's ending in 5157F, criminal trespass, be 12 months, serve 17 days. And credit for time served, balance suspended, stay away from the racetrack at 420 East Crossville Road in Roswell, and that would run concurrent with the prior case, and the state would move to dismiss or null pros the FTA. Ask that he stipulate to identity, venue, and a factual basis for the plea. Thank you.
White.
And Judge, we do stipulate for the purposes of the plea, again, just ask for a waiver of probation fees of 2 months. He has been in jail 183 days at this time, so any fee waiver would be helpful, and as to his probation, go to non-reporting once he completes all his requirements.
Okay, Mr. Dewberry, it's my understanding that in case 21 CR 007242G, you wish to plead guilty to simple battery. And in case 22 CR 005157F, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir. No,
Are you under the influence of any drugs or alcohol this morning?
sir.
You've been represented by counsel. Are you satisfied with his representation?
I think he said anger management and probation.
Okay, that's not my question though. Are you happy with what Mr. White's done for you?
I'm trying to understand. Did he say?
Okay. Yes, he's if the court accepts the terms of the probation, which I plan on doing, it will be 12 weeks of anger management, and that you'll have to stay away from MARTA for the simple battery. And for the criminal trespass, it's basically time served and stay away from the racetrack.
Yes, sir.
Is that your understanding, Mr. Dewberry?
Yes, sir.
Okay. So if you're satisfied with that, are you satisfied with what Mr. White has done for you? You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay. I will accept the plea as negotiated, Mr. Dewberry. I will waive the first 2 months of your probation fees to help you get on your feet. And when you complete the terms, I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you, Your Honor.
All right. All right, it is 36 Johnson.
It's also a negotiated plea, Judge.
Thank you. Good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? You have to speak up for me.
Yes.
Thank you. Yes, Ms. Evans-Battle.
Yes, as to count 1, 12 months, serve 60 days, credit for time served, balance probated, complete the Operation 21 law and decision-making course, stay away from Target at 375 18th Street Northwest. There's restitution in the amount of $400.92. As to the simple battery, 12 months, serve 60 days, credit for time served, complete 8 weeks of anger management classes, 40 hours of community service, no further contact with Gerard Gaspard. And this would, we would ask that he be continuous reporting for that 12-month period of time. Ask that he stipulate to the identity, venue, and a factual basis for the plea. Thank you.
All right.
Your Honor, we do stipulate for the purposes of the plea. We would ask to waive 4 months of probation fees for Mr. Johnson. He does have $400 in restitution to pay that could help him apply to that. He's going to be in jail another 12 days. And yeah, I understand the state wants him to continuously report, but I mean, I've made this argument many times. The only thing that they do on reporting is come in and collect the $50 and then tell him to leave. So once he's completed all the requirements, we'd ask that he go non-reporting.
Okay, Mr. Johnson, it's my understanding that in case 26 CR 002365L, you wish to plead guilty to theft by shoplifting and simple battery. Is that correct? Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time? Say it again for me.
No.
You've been represented by counsel. Are you satisfied with his representation?
I have a question. So I have to check in 1 day and then I'm out.
That's correct. Like we discussed yesterday, you have another 12 days and you'll be released.
All right, I'm fine. That's fine.
Okay, so my question to you was, are you satisfied with Mr. White's representation?
Yes. Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right? Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Given that the state would like for you to continuously report, I'm going to waive all the probation fees while you're on probation to help you stay on your feet. Good luck to you.
Thank you, Judge.
You're welcome.
Excuse me, Judge, who is the restitution going to talk? They didn't state.
I assume
There was a loss from Target. Do you need the address? Or what information? do you need?
Thank you.
All right, thank you.
Okay, who do we have next?
Number 50, Mr. Peter Walker.
Good morning, Mr. Haddad. How are you today?
I'm doing all right, Judge. On Mr. Walker, Judge, we are, just 1 second here, huh? Judge, we're requesting a no plea on this case, and also it's gonna be a non-negotiated as far as the jail portion of the sentence, Judge.
How many days has he currently served?
As of today, Judge, it'll be 18 days.
Good morning, Ms. Stallworth. May I get the history, please?
Good morning, Your Honor.
Good
Yes,
morning.
Mr. Walker has 8 cycles total, 1 from Tennessee, 1 from the state of New Jersey. There's a 2024 conviction from Hamilton County, Tennessee for disorderly conduct. He's currently on probation out of DeKalb County for simple assault. There's a 2022 conviction from Forsyth County for criminal trespass, and another 2022 conviction also from Forsyth for criminal trespass. Nothing further.
Given that he's had criminal trespass convictions and is currently on probation for simple assault, I'm not willing to allow a no-lo in the case, Mr. Dodd.
That's fine. Walker, we can proceed with a guilty plea, Judge.
Okay, and I'll consider the days. Let me hear what the facts are in that regard, and I'll let you know. Yes, Ms. Evans Battle, can you give me the facts of this matter?
Yes, Your Honor. Okay, in this case, it appears that the incident happened April the 10th of 2026. Officers responded with an assist for another officer at the World of Coke. It appeared that that Mr. Walker was actively fighting her. Sergeant Brewer is a female retired officer. In making contact with the suspect, the officer indicated that his eyes were red and watery and mucus was running from his nostril with exposure to pepper spray, in which Sergeant had deployed her department issue pepper spray before the officer had arrived. She advised that he had been on the property without authorization, had been asked multiple times to leave the premises, and he refused to comply with the request. She was contacted by the head of security, and they were attempting to remove him from the property, initially voluntarily, but after he didn't comply, then she was attempting to remove him and grabbed the right hand, and that he grabbed her right hand and attempted to strike her. And in response is when she deployed the pepper spray at him. So he's charged with the simple battery as well on a police officer, as well as the criminal trespass for refusing to leave the property once asked to do so.
Recommendation?
The recommendation is for 12 months, served 60 days, credit for time served, balance probated. We would ask that he complete an MHET. If the court so finds, of course, the anger management is part of the recommendation. No further violent contact with law enforcement. As to the criminal trespass, 12 months probation with 40 hours of community service. Nothing further, Your Honor.
Thank you. Mr. Haddad?
Your Honor, on behalf of Mr. Walker, my client is 29 years of age. He reports to me that he does live with his mother in Lithonia. He has some college, and Judge, as far as the currently unemployed judge, he is actively looking for work. He used to work at Walmart in Lithonia. As far as the facts of the case, Judge, Mr. Walker disputes a portion of the allegations, Judge. Specifically, I think the contention is that he was actually pepper sprayed before he did anything. He was reaching for his backpack to leave the property, and it was pepper sprayed. Judge, in any event, he spent 18 days in custody. I would argue that he got the brunt of the punishment from having pepper spray in his eyes, Judge. I think 18 days is I think would be appropriate. He can do the community service. I would ask the court to consider waiving some of his probation fees. He does live in DeKalb. Transportation is going to be an issue as well. And that's the request of the defense, Judge.
Okay. Mr. Walker, it's my understanding that in case 26 CR 002391J, you wish to plead guilty to simple battery against a police officer and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept your plea, Mr. Walker. The court sentence will be 12 months to serve 36 days, credit for time served 18 days, balance probated. I'll accept the rest of the state's recommendations with the MHET, 8 weeks of anger management, and no further violent contact with law enforcement. As far as the criminal trespass, I'll accept the state's recommendation regarding that charge as well. I will waive 3 months of your probation fees to help you get on your feet. And when you complete the terms of the probation, I'll have it go to a non-reporting status.
All right, thank you, Judge.
You're welcome. Good luck to you, sir.
Good morning, Your Honor. Good morning, everybody.
Good morning, Officer Milton.
Sitting before you is position 1, Christy Allen.
And Your Honor, I apologize on Ms. Allen. It'll be non-negotiated only as to the no further, the stay away as opposed to no further violent contact, Judge. The recommendation is what's on the calendar, Judge. The issue is that there are 2 daughters, Judge. The first daughter is 15, I believe, and the recommendation is no further violent contact. The other one is a younger 8-year-old, Judge, with a stay away. I'm not sure if Ms. Evans Battle had the opportunity to reach out to the father, and maybe I'm speaking ahead of you, Ms. Evans Battle.
You are. I was trying to send an email, but yes, it can be no further violent contact. We were able to reach out to the father.
I apologize, Judge. Then it is a negotiated plea. We're ready.
Okay, very good. Good morning, Ms. Allen. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You can place your hand down. Yes, Ms. Evans Battle.
Yes, as to count 1 is 12 months, serve 30 days, credit for time served, balance probated, complete the FVIP and 20 hours of community service, no further violent contact with her 15-year-old daughter. As to the second count of simple battery, family violence, 12 months, serve 30 days, credit for time served, balance probated, complete the FVIP, 20 additional hours of community service, no further violent contact with the 8-year-old child. We ask that she stipulate to identity, venue, and a factual basis for the plea. Thank you.
Mr. Dodd?
Your Honor, we stipulate for purposes of the plea, Judge, I would ask the court to consider waiving the first 2 months of probation fees, since the classes obviously cost some money, Judge.
Ms. Allen, it's my understanding that in case 26 CR 002409Y, you wish to plead guilty to simple battery, 2 counts of simple battery family violence. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Allen. I will waive the first 2 months of probation fees to help you get on your feet. And when you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, ma'am. You're welcome.
Please. Okay, next we have position 5 through 7, Miss Bradley.
And who's Miss Bradley represented by? Is this one of Miss McLeod's cases?
Oh, you need a Miss McLeod?
Oh, here, yeah, yes.
Morning, Your Honor.
Good morning, Miss McLeod.
I represented her, Your Honor, but the last time she was in court with Judge Edie, she indicated to him that she did not wish for me to represent her. And Judge Edie had said he would be putting in an order for me not to represent her anymore, but I see that she's in custody and there's no order in place. So I am happy to speak to her to communicate the state's plea offer if she wishes to speak to me.
Okay, good morning, Ms. Bradley. You have been charged in case 24 CR 007416Y with battery, family violence, and criminal trespass and damage to property. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We're offering you the assistance of Attorney McLeod here if you choose to utilize her service. Would you like to utilize Ms. McLeod's service today?
Yes, Your Honor.
Okay, very good. So, Ms. Bradley, I'm going to have Ms. McLeod call you and speak with you about these charges, okay?
Mm-hmm.
Thank you, ma'am. Thank you, Ms. McLeod. And Ms. McLeod, do
You're
you
welcome.
also represent positions 12 and 13, DeMarcus Carr?
I represented Mr. Carr in a case that was closed, Your Honor, and I was unaware that he was in jail on this case. But the
Okay.
case that I previously represented him on is now closed, has been closed for some time.
Okay. If we have him present this morning, would you mind speaking with him in regards to these charges?
That's all, Your Honor. I can speak with him.
Okay. And you also, I believe, have position 35, Ms. Vasquez. Is that right or not?
That's,
No, Your Honor, I think that may be Mr. Murphy's.
Oh, okay. All right. So thank you. So if we're gonna have also, if we were gonna have Mr. Carr present, courtroom 2, if you'll make him available to Ms. McLeod at some point after she's, thank you. Okay, who do we have next?
Is position 10 and 11, Ms. Byrd?
Also a negotiated plea, Mr. Haddad?
yes, Judge, it is.
Okay. Good morning, Ms. Byrd. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You can place your hand down. Ms. Evans Battle?
Yes, Your Honor. We're asking for 12 months probation, credit for whatever time she served. I'm not sure if she served any time. I don't see it. Balance would be probated, 3 parenting classes, 40 hours of community service, complete the Operation 21 law and decision-making course, that she stipulate to identity, venue, and a factual basis for the plea, and the state would move to null pros her FTA at this time. Thank you.
Judge, we stipulate for purpose of plea, Judge, Ms. Byrd has spent 11 days as of today on this case, Judge, so she gets credit for that. And I would also ask the court to terminate probation upon completion of all the conditions, Judge.
Okay. Ms. Byrd, it's my understanding that in case 25 CR 004154D, you wish to plead guilty to reckless conduct. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Ms. Byrd. I will waive the probation fees to help you get on and stay on your feet. And when you complete the terms of the probation, I'll have it terminate. So the sooner you get it done, the sooner you're not going to be on reporting, you're not going to be on probation, okay?
Yes, sir.
All right, good luck to you.
Thank you.
Judge, that's all the fees, correct?
Yes, ma'am.
Thank you.
Wilbur. All right, next we go number 53, Mr. Wilbur.
This is going to be a bond hearing.
It is, Judge.
And can someone tell me what the present bond is? And
Your Honor, his present bond is $1,000 good bonds. And it was set on April 13th, Judge. I'm not sure which judge it was, Judge. But I can.
Ms. Evans Bell, are you able to pull that up for me?
Yes, just one moment, please. I guess I didn't look that far down. Okay.
Your Honor, Judge
I'm sorry, say it again for me, Mr. Dodd.
Judge Law,
Okay,
I'm
thank
s-
you. And may I get the history, Ms. Stallworth?
Your Honor, he has 21 cycles total, one from the state of South Carolina. There's a 2021 conditional discharge from Jackson County, Georgia for possession of a Schedule 1. There's a 2023 conviction from Fulton, case number 21 CR 003724F for affray. There's a 2019 conviction from Catoosa County, Georgia for forgery, 3rd degree, and a 2015 conviction from Covington Municipal for criminal trespass. There's a 2023 FTA from Fulton County and a 2016 FTA from Lawrenceville Municipal. Nothing further.
and Your Honor, I apologize, I misspoke. The Odyssey has Judge Law, but when I clicked on the order, the bond order, it looks like your signature, Judge.
Okay, all right, thank you. Yes, Ms. Evans Battle.
Yes, Your Honor, and okay. So in this particular case, it appears that the incident happened on April the 11th of 2026, where he was brandishing a knife to block the entrance to a bedroom. The victim in the case is Contarius Hannon. And this happened at 1130 Dolphin Drive Southwest. There appeared to be a dispute between the parties. This is a live-in program housing facility, and it was discovered that it's Mr. Hannon. Apparently there was a bug that was crawling on his arm. He squashed it and brought it to Mr. Wilburn's attention, which started the argument. Wilburn told him that he was no longer welcome and needed to be removed from the residence. And Hannon had been staying in the apartment with him since November of 2025. Well, of course, the officers told him that he could not just depossess him of the property just by telling him to leave. He had to follow legal proceedings to do so. Wilburn, I think, indicated that he was actually the person on the lease and that it was program housing and he wasn't supposed to have anyone there. It says that he came back into the apartment. Wilburn went back into the apartment and came back outside with some belongings and saying that he's going to get his uncle and cousin and he was going to come back. He walked up the street, turned around, came back, dropped off the belongings and came back outside. When he appeared to have left the scene. So at some point in time, while all of this was going on, he stood in the doorway with a knife, and Mr. Hannon felt threatened by that act. And the state has a photograph of him standing with a big old butcher knife. So that's the allegation as to the simple assault.
And I take it that the state objects to any reduction of the bond.
Not in consideration of his history and the facts of the case, we would object.
Okay, thank you, Ms. Evans Battle. Mr. Dodd, I've looked back at my notes from the April 13th SEA calendar. I was the one to handle that calendar. At the time, I also noted that I wanted him to have a social worker visit for BHET. Do you know if that has occurred?
Yes, Judge, it's, social worker did see him, Judge. I would just briefly, Judge, if I may, and I understand the courts as far as the bond, but if the court possibly can consider a time served, and here's the facts, Judge. Mr. Wilburn is in a safe house program, and he has got a caseworker. The room that he has is provided by the safe house. And one of the conditions, of course, is he's not supposed to have anybody in there. He was kind enough to allow Mr. Hannon to come in and stay, but of course, he was not supposed to. And reach out to the caseworker. Caseworker said that you need to contact the authorities and so have him leave. Of course, a due process involved with that, which is how the police got involved to start with, because my client called and wanted that person out of the residence. Mr. Hannon at some point, Judge, brandished a samurai sword, which prompted my client to grab a knife in self-defense. The issue is, Judge, that Hannon's no longer at that residence. My client, if he's not, if he does not return to that property in the next couple of days, Judge, that apartment is no longer, that room is no longer available through safe house. He has a series of health issues, Judge. I'm trying to get him out. He's computing as laid out by the state judge. And again, every indication I have, Mr. Hannon has moved south of Florida, where he's originally from. So I would ask the court, I understand if the court is not inclined on a signature bond through pretrial services, if the court would consider a time served sentence, Judge.
How much time has he served? I guess that's
18 days.
18 days, okay. And the safe house, that's the Dolphin Drive address? Is that correct?
Yes.
That
All
is,
right.
or,
And he's welcome back to that location?
yes, Judge.
Okay, so I will allow him to go back there as long as Mr. Hannon is not there. So I'll give him a one-time escort, police escort. If Mr. Hannon's not there, then he can stay if they welcome him back. If not, he'll have to gather his belongings and find somewhere else to go. What about the other request of the state?
Donna D, he relates to me that he actually is part of the safe houses. He gets anger management through Mercy Care. I've not been able to confirm that, Judge. But I think perhaps either continuing, assuming he's currently going through that type of program, or in lieu of just the anger management classes might be helpful in this case, Judge.
Okay, so just so I'm understanding, there's no objection to the MHET and the 12 weeks of anger management.
That is correct, Judge.
Okay. All right, so I am inclined to, given the situation, for the sentence to be 12 months to serve 36 days, credit for time served 18 days, balance probated with the rest of the requirements of the state. I do want him to be on continuous probation for those 12 months, but I will waive the fees during that time.
Thank you, Judge. And Wilburn is ready to proceed by entering a guilty plea, Judge.
Okay. Mr. Wilburn, it's my understanding that in case 26 CR 002378G, you wish to plead guilty to simple assault, family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir, but I do take medication.
Okay. You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right? Has anyone forced or coerced you to plead guilty? I'll accept the plea as negotiated, Mr. Wilburn. The court sentence will be 12 months to serve 36 days, credit for time served 18 days, balance probated, and MHET, 12 weeks of anger management, no further contact with Mr. Hannon. I will allow you to go back to the Dolphin Drive address with law enforcement. If Mr. Hammond is not at that residence, then you are allowed to stay there. If he is, you'll have to collect your belongings and find someplace else to stay. I'm going to require that you be on probation for the entire 12 months, but I'll waive the fees while you're on probation to help you stay on your feet. Good luck to you, Mr. Wilburn. Good morning, Mr. Murphy. Do you have an announcement? I believe that your case is Miss Ivanskiv.
Yeah, that should be position 35. Judge, have not been able to place her, and that was what you required for signature bond. So I'm just going to file a waiver today.
Okay.
Can I say something?
Ms. Ivanskiv, you have a right to remain silent. Anything that you say can be used against you. I take it that's your, well, Mr. Murphy, why don't you give her a call and answer
Yeah,
any of your
I think that's the
questions?
best thing. If the jail can call me right now, ACDC, I'll take the call. Thank you, Judge.
Okay, yes, well, so we'll note this as a waiver and the case will be returned to the division judge.
Your
Okay,
Honor,
yes,
can we do, Miss
Bradley.
Yes, Miss Bradley, come on up, have a seat.
and yes, what are we doing with Ms. Bradley this morning, Ms. McLeod?
This is going to be a negotiated plea, Your Honor.
Okay, very good. Good morning again, Ms. Bradley. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You can place your hand down. Yes, Ms. Evans Battle.
Yes, Your Honor. As to the case ending in 7416Y, it would be on count 1, 12 months, served 32 days, credit for time served, balance probated, complete the FVIP, and no further contact with Donardo Mathis. As to count 2, 12 months, served 32 days, credit for time served, balance probated, complete 40 hours of community service. As to the case ending in 6045Y, it would be 1 count, so it's 12 months served, 1 day, credit for time served, balance probated, complete the FVIP. And no further contact with Wayre Melson. Ask that she stipulate to identity, venue, and a factual basis for the plea. And I think there's an FTA.
There
is.
And we would move to null pros that as a part of negotiations of the plea. Thank you.
Ms. McLeod?
Yes, Your Honor, we do so stipulate. And after speaking with my client, Your Honor, we are requesting that her probation go non-reporting once she has completed all her requirements.
Okay. If nothing further, Ms. Bradley, it's my understanding that in case 24 CR 007416Y, you wish to plead guilty to battery, family violence, and criminal trespass and damage to property. And in case 25 CR 006045Y, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir. Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Bradley. When you complete the terms, I'll have the probation go to non-reporting. So the sooner you get it done, the sooner you won't be on reporting probation. Good luck to you, ma'am.
Let's say, Your Honor.
Thank you, ma'am. You as well.
Thank you, Your Honor. And With respect to Mr. Carr, Your Honor, it is not going to be a plea, but I was hoping we could address the issue of his bond.
Okay. Is this Mr. Carr in courtroom 2?
It is.
Okay, thank you. What is, can someone tell me what the current bond is and who issued it?
Your Honor, I believe he had a bond and then he missed court and his bond was forfeited. That's my understanding.
Oh, okay.
I had not much effort or opportunity to look at the case yet.
All right, so as you know, Ms. McLeod, my normal practice is that if he missed court with someone else, that he's returned to the division judge that he missed court with for them to consider whether or not they wish to address the issue of bond again. So I can have the case returned to whomever the division judge was for them to address that issue.
Your Honor, my client tells me that he's expecting his first child and he's really very concerned. He wants to be out to be at the birth of the child. And that is one of the reasons why we wanted to look at the issue of his bond. Because based on his current situation, it appears that he may miss that event unless he gets the opportunity to get out of jail.
Okay. Can somebody pull up the bond for me? The current bond?
I'm sorry, what case is this? DeMarcus?
Position number 12, DeMarcus Carr.
Okay.
Well, who is the child with that's going to be born with Chakara Jones?
No,
No, Your Honor, Chakara Jones is his sister.
Oh, okay.
Judge, it was.
Yes.
The bond was signed by you and it was a total of 11,000 pretrial services on April the 14th, 2025, looks like.
Can you tell me, Ms. Evans Battle, what court date he missed?
Yes, it is, he missed September the 23rd of 2025. There was a bond forfeiture judgment entered on 3/27/2026. And that's where
Your Honor, I did see a return to sender also in the file.
Was there a return to sender?
I did see one in the file, Your Honor. Yes.
Okay, well, let me look. I don't see it unless the clerk can see it.
Judge, I see a return to sender on 8/28/25.
And the notice was sent, is this the same notice that that he missed?
I believe so, Your Honor. I believe that's the one he missed, yes.
No.
Yes, sir. Yes, sir. The notice was returned on August the 28th of 2025, and the plea and arraignment was for September the 23rd of 2025.
Okay. Do we have his proper address at the present time?
I do not, Your Honor, but I can get it from him.
Well, I need to make sure that find out what.
Yeah, what's the address, Ms. McLeod, do you know?
I do not.
Can we have your client tell us the address?
Yes, Your Honor. Mr. Carr, we need your good mailing address where you can get your mail, so you won't miss any more court dates.
36 Macon Place.
Is there an apartment number? Because that's the address that we have in the system, Atlanta 30354.
Oh, that's the house.
That's where the notice was returned from.
Did anybody else live there with you, Mr. Carr?
Grandma. And my uncle's now.
Okay. All right, well, Mr. Carr, it is your responsibility to make sure that you maintain contact with the court to make sure that you don't miss a court date. I haven't heard anything. It appears that as far as pretrial was concerned, that you were reporting as you should. I was the one apparently to give you the bond. And since there was a return to sender for whatever reason, it's normally my practice that I will allow one set aside. So I'm going to set this aside. And if you miss any more court dates, it won't be set aside in the future. It's your responsibility to keep up with the court to make sure that you don't miss any dates, okay?
And Mr. Carr,
you understand what I'm telling you, Mr. Carr? Yes, Ms. McLeod.
and Mr. Carr, as soon as you get out, please get in touch with me, okay? That's
Yeah, ma'am.
important.
Yes, ma'am.
All right, so I'll set it aside. We'll return it to the division judge.
Thank you, Your Honor. And that
Yes.
concludes my business for the court today. May I be excused?
Yes, thank you for assisting us, Ms. McLeod. We appreciate it. You have a good day.
Judge,
You too, Your Honor.
Yes, Mr. Murphy.
on position 35, Ms. Vasquez is advised that she's in the process of lining something up with a facility. So if you could reset that to May 5th, Judge, and perhaps if she's got something scheduled in the next day or so, I'll reach out to Michael Jordan.
Okay, so we will reset position 35 for the SAP calendar on May 5th.
Thank you, Judge. Sorry for the inconvenience. Appreciate
No
it, Judge.
worries. Have a good day, Mr. Murphy.
Thank you, Judge.
Next is position 37 and 38, Ms. King. I'm sorry, correction, Your Honor. 32 and 34, Ms. Hunt.
This is a negotiated plea.
I just probably not.
I wanted to confirm with Ms. Evans Battle, since we've exchanged emails, that it would be a total of 80 hours with the other conditions. Is that correct?
Yes, and she'd have to enter a guilty plea on one count of cruelty to animals, and she can do no on the rest.
On that, I'll have to ask my client. I understand the safe position, but my client is adamant it can be. She wants a no plea, judge. She does dispute the facts of the case. Ultimately, she says it's not her dog. So that's where we're at, judge.
Is the dog located at the residence where she was staying?
No, Judge, it's kind of a duplex. The dog was next door. My client was visiting apartment A. I think the dog technically was in apartment B. The officer the animal folks I can't think of the word right now, couldn't figure out whose dog it belonged to. So they cited both my client and the owner of apartment B. And that was basically it. I mean, my client is adamant that is not her. She didn't live there at that apartment. She doesn't know anything about this dog. She's trying to get out, honestly, Judge. She's got.
Is she only in on these charges?
Yeah, I believe so. Just 1 second. Let me just double check and confirm.
She failed to appear. I think I have 2 failure to appears on this case.
And she does, Judge. So the first failure to appear, Judge, was because I believe the address was, the notice was that address was removed. And she got arrested the first time, she posted bonds, and then she moved again, contacted the bonding company, but of course neglected to inform the court. The bonding company eventually told her, you should have contacted the court. That's why she's back in custody. It's a 2023 case. It's a $5,000 cash only bond, Judge. She's got 7 kids. That's basically where we're at, Judge. I mean, I would love to ask for a signature response from pretrial services, but I understand. I mean, on record, she's missed court twice, and I've talked to her about that, Judge, which is why we explored the possibility of entering a NOLA plea, because she really wants to get out and go back. She was working at DoorDash and had gotten a job at Family Dollar, I think. So that's where we're at, Judge. She doesn't appear she has any other arrests since its case came about, but I don't know 100%.
Who's the division judge?
Division E, Judge Morrison.
Okay, well, yes, Ms. Evans Battle.
I was gonna say, she does have, another arrest. It's in another county. I don't know the status of it. Since this incident, there's an allegation of a kidnapping and battery out of DeKalb County from, arrested in June of 2024. She has a shoplifting, from Atlanta PD arrest from June of 2024. Then she has the FTAs.
And there are 2 cruelty charges. Were there 2 different dogs?
It does not appear that there were 2 different dogs. There were 2 different allegations, if I remember looking at the accusations here.
I don't understand why there are 2 different cruelty to animals if it's the same offense date.
I am not certain if it's the same, say, female American Pit Bull type.
Honor, while Ms. Evans Battle looks into this, Judge, ultimately what I'm at, I mean, it's a time served sentence. I'm asking for a NOLA plea. Judge, I believe she's technically eligible to enter a NOLA plea, Judge, and I would ask the court to allow her to enter a NOLA plea with the 80 hours community service and the BARC online course. And community service instead of fine, Judge, it's 80 hours.
Okay, well, I'm trying to, if it's only, I would think that one of the cases would be possibly null-prossed by the state if it's the same dog and if it's the same incident date. So that she would only have 1 NOLO to cruelty to animals and the rest of the charges. So right now, it's my understanding that the state is asking for $500 per cruelty to animal charge.
Well, we were, or the community service, but we were
Right.
in agreement with the 80 hours of community service as a total amount on this case. I was trying to see if there was some, if it was another animal. Okay. Yes, it's the same animal.
So, Ms. Evans Battle, would the state consider null processing one of these cruelty to animal charges and proceeding on the other?
I guess we would probably say that it merges. I mean, I think it's the same event.
Okay. Okay, so what the court will consider, Mr. Dodd, is if the second cruelty to animals is going to merge into the first, I'll consider a NOLO on the on the charges. Therefore, for the only cruelty to animals, it will be a 50 hours of community service and the BART course. For the tethering, 30 hours of community service. For the vaccine, I guess 30 hours of community service instead of the fine. And for the no tag, 12 hours of community service. Mr. Dodd?
Ms. Hunt, do you wish to proceed with the plea? It'll be probation, essentially, time served with the community service that the judge just mentioned, and the online course that I mentioned to you yesterday. I think, well, she's on mute, Judge.
Officer Milton, we need you.
Sorry, Your Honor.
Okay.
So Ms. Hunt, proceed with the plea. Time served and community service, as the judge mentioned, and the online course that I discussed with you yesterday.
Yes.
We're ready to proceed, Judge.
Okay. Anything further, Ms. Evans Battle?
No, no, Your Honor.
Okay, thank you. So Ms. Hunt, it's my understanding that in case 23 CR 007384E, you wish to plead NOLO to cruelty to animals, tethering, no proof of current rabies vaccination, and no Fulton County license tag. Is that correct?
Correct, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Correct, Your Honor.
You understand that you have a right to a trial by jury on these charges and that by pleading NOLO to them, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead NOLO?
No, Your Honor.
I'll accept your plea, Ms. Hunt, with the sentence that's already been articulated by the court. Good luck to you, ma'am.
Mhm.
Oh, before you go, I will waive the first 2 months of probation fees to help you stay on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status. Good luck to you, ma'am.
Judge, I apologize. I was on mute. I wanted to ask if she could, there be a condition regarding the owner owning and caring for animals while on probation, that she cannot own or care for an animal while on probation. That's usually standard for these type of cases.
Does she have any animals, Mr. Dodd?
No, Judge, since it was not, she's shaking her head, so.
In my animal. It wasn't my animal.
Okay, so we'll add the stipulation that as well, that you cannot own any animals while on probation. All right, good luck to you, ma'am.
Yep.
All right, next we got position number 44, 45, Mr. Bosco.
Mr. White, if you have the opportunity,
Sure,
Mr. Robinson.
I have, Judge, and we are going to be entering a waiver in that case. And also, we would ask that his $4,000 cash bond be converted to a surety bond, and any reduction in that we could get. I understand that you don't normally handle these cases, but received an email this morning from one of our Superior Court side attorneys who has another case with him that has requested this.
Okay, what are the charges, and has he made bond on, and I don't understand that request, I guess.
Well, Judge, it's currently a cash bond. It looks like he missed court. And so the bond was converted to a cash bond. And my understanding from talking to Mr. Robinson this morning is that he has a deal in place on his felony charge. But his attorney told him that he should not enter a plea to this case this morning. He thinks it's a weak case, maybe has something to do with another case, and that once is requesting that the cash bond be converted to a surety bond.
I take it he's going to enter a plea on that other matter. Do you know when that's going to be?
My understanding, I believe he said the end of May or early June.
Okay. So if that's the case, then I don't understand why returning this to the division judge would be a problem. Given that he's going to be in custody anyway.
Judge, well, I mean, he would be in custody, but considering the division he'd be going to, he may be in custody months before he sees a judge again.
You want me to put him back on an SAP calendar and just hold it on this calendar?
I guess we could reset him 2 weeks, Judge, and then I can reach out. I just got that email from his attorney about 5:30 a.m. and obviously I didn't have a lot of time to speak with Mr. Robinson this morning.
Okay. All right. So if you want to, why don't we just leave it on the SAP calendar on one of my calendars in May, and we'll come back and discuss it once he enters the plea. Okay. So, okay. Well, let me get a date down.
We can do the 12th, 19th, or the 26th.
The 12th is 2 weeks from today. Yes. Let's do that. And we may end up resetting it again, but at least at that time I can talk to him and have a little more information.
Okay. So 5/12. All right. We'll see you back on the 12th, Mr. Robinson.
Next is position 37 and 38, Ms. King.
And this will be a negotiated plea, Mr. Dodd?
Your Honor, just 1 second, Judge. Yes, Judge, we can resolve it by negotiated plea. The reason I was hesitating, Judge, is that the recommendation was the FFIP. I've discussed that with Ms. King yesterday. I attempted to change it, but Ms. Evans Battle is requesting the FFIP, and my client is ready to proceed. This is essentially a time-served sentence, Judge. I would ask for 1 trip back to the residence to retrieve any belongings, if she has any. I'm not sure, Judge, but Ms. King had somewhere else to live. The alleged victims on the first case, number 37, is the mother, and number 38 is the other boyfriend.
Okay, so she wants a one-time escort back to the Drexel Lane address?
Yes, Judge, and I would ask the court to waive the first 2-3 months of probation fees as well.
Good morning, Ms. King. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, you have to scooch up or speak up for me.
Yes, Your Honor.
Okay, very good. Thank you, Ms. King. Yes, Ms. Evans Battle.
Yes, as to the case ending in 2428J, it would be 12 months, served 30 days, credit for time served, balance probated, complete the FVIP, no further, no violent contact with Jessica King, but still stay away from the 3280 Drexel Lane. We're asking for medication compliance. And as to the case ending in the 5377J, it would be 12 months probation, serve 30 days, credit for time served, balance probated, 40 hours of community service, no further violent contact with Dennis Clark, complete an ADET or proof of compliance. And I think that when she was out previously, that was one of the conditions of her bond. So that's why we asked for proof of compliance with that. That she stipulate to identity, venue, and a factual basis for the plea. Thank you.
Thank you, Mr. Dodd.
Your Honor, we stipulate, ask the court to follow the state's recommendation.
Okay, Ms. King, it's my understanding that in case 26 CR 002428J, you wish to plead guilty to terroristic threats and acts. And in case 25 CR 005377J, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
I do.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Ms. King. I will waive the first 2 months of your probation fees to help you get on your feet. I'll allow you a one-time police escort to retrieve any belongings from the Drexel Lane address. And when you complete successfully the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, ma'am.
Thank you.
Your Honor,
welcome.
can we do position 42 and 43? Because I have to go and get position number 2, Miss Barber, from the 4th floor.
Okay,
Thank you.
this is also going to be a negotiated plea, Mr. Dodd.
It is, Judge.
Okay, yes, good morning, Ms. Pearson. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, ma'am. Yes, Ms. Evans Battle.
All right, yes, Judge. As to count 1, it'd be 12 months served, 44 days, credit for time served, balance probated, 40 hours of community service, stay away from the Walmart at 4735 State Route 138, which is Jonesboro Road in Union City. As to count 2, the state would, it would merge into count 1. The state would move to null pros the FTA as part of the plea negotiations. Ask that she stipulate to venue, identity, and a factual basis for the plea. Thank you.
Yes, Mr. Dodd.
We stipulate for purposes of plea, I would ask the court to consider terminating the probation upon completion of the conditions, Judge.
Okay. Ms. Pearson, it's my understanding that in case 24 CR 004843B, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Pearson. When you complete the terms of the probation, I'll have it terminate. So the sooner you get it done, the sooner you won't be on probation. Good luck to you, ma'am.
Thank you.
You're welcome.
Thank you, Your Honor. I'll be back
Okay.
shortly.
Okay. Who do we have next?
55 to 58, Mr. Wilson.
And what are we doing with Mr. Wilson today?
Your Honor, that's gonna be a negotiated plea, on both of those cases, Judge. And I would ask the court to consider terminating or non-report probation upon completion of the conditions, Judge.
Okay. Good morning, Mr. Wilson. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you Good morning, sir. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? You can place your hand down. Thank you, sir. Yes, Ms. Evans Battle.
Yes, as the case ending in 4596E, the recommendation is 12 months, served 30 days, credit for time served, balance probated. As to, for him to stay away from the Walmart located at 5200 Windward Parkway in Milton. As to 5229L, count 1, 12 months, served 30 days, credit for time served, complete 40 hours of community service, no further contact with Mr. Shankavasi. Stay away from 12990 Colburn Road in Milton. And as to count 2, 12 months probation, stay away from the location at 12990 Cogburn Road in Milton. So the that would run concurrent with the other case. Stipulate to identity, venue, and a factual basis for the plea.
Were there 2 different times for these criminal trespasses in position 56?
Yes, Your Honor.
Okay. Yes. Whenever you're ready, Mr. Haddad.
Your Honor, we stipulate for purpose of the plea, both of these incidents happened back in 2025. They're 6 or 7 days apart, Judge, 2 different locations. It's a time served sentence, Judge. I would ask the court to follow the recommendation and consider terminating or non-reporting upon completion.
Does he require any assistance with a social worker to assist with housing?
No, Judge.
Okay. Mr. Wilson, it's my understanding that in case 25 CR 004596E, you wish to plead guilty to criminal trespass, and in case 25 CR 005229L, you wish to plead guilty to 2 counts of criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir, 100%.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Sir.
Has anyone forced or coerced you to plead guilty?
No, sir, not at all.
I'll accept the plea as negotiated, Mr. Wilson. When you complete the terms of the probation, I'll have it terminate. So the sooner you get it done, the sooner you won't be on probation. Good luck to you, sir.
I appreciate it.
Thank you, Judge.
All right, next we got number 46 and 47, Mr. Rucker.
Yeah, time served sentence. Judge, I apologize. We're ready to proceed on Mr. Rucker. It's a negotiated plea. It's essentially just a time served sentence.
Okay. Good morning, Mr. Rucker. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can place your hand down. Yes, Ms. Evans Battle.
Yes, in case ending in the 8261J, criminal trespass, 22 days that he served, we'd ask the court to commute that time to time served. And as to the fair evasion and count 2, 22 days has been served, we'd ask the court to commute that time to time served. This case He has the additional open case ending in 2501. It is time served as to count 1, as to count 2, and we would null pros count 3 as part of the plea negotiations in this case. I believe he has another felony probation case in place. We'd also ask that he stay away from all MARTA premises. That would be in accordance to any active suspensions or bans. Stipulate to identity, venue, and a factual basis for the plea. Thank you.
Judge, we stipulate for purpose of plea, ask the court to follow the time served recommendation from the state, Judge.
Mr. Rucker, it's my understanding that in case 25 CR 008261J, you wish to plead guilty to criminal trespass and fare evasion. And in case 26 CR 002501, you wish to plead guilty to certain acts, bus, rail station prohibited, and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right? Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Rucker. Good luck to you, sir.
Judge, just so the clarification, count 3 is a criminal trespass on the second case, and the state moved to null pros that case.
Okay, thank you, Ms. Evans-Brown.
Excuse me, Judge, so on the second case that's not on the calendar, Ms. Evans Battle, can you call out the correct way of how the charges should be? Because they're not listed in the system, not on the calendar. So it's count 1, the certain bus act. Count 2 is criminal trespass, and count 3 is willful obstruction, if I'm not mistaken. Is that how it should be?
Can I settle that today? That's Thursday.
No, no. They're just- No.
If you, Ms. Evans-Bell, you are on mute there if you're talking to us.
Yes, I apologize. Yes, so it is certain acts would be count 1, criminal trespass is count 2. So the third one would be the willful obstruction. That would be the one that would be null pros. I apologize. I'm
No problem, thank you.
some notes.
Thank you, Judge.
Okay. Who do we have next?
Position 2, Ms. Barber.
And this is a negotiated plea.
Yes, Judge, except that the recommendation has changed from the published calendar. Essentially, it's a time served, balance suspended. Is what the recommendation is, and that was negotiated between the trial division, ASP, and the trial division, public defender judge. Ms. Evans Battle, specifically Jennifer Spear, I believe forwarded.
She did, but that wasn't the way I read it.
It's supposed to be 12.
This says 12 months probation, 180 days with credit for any time already served, and look like she's done 48 days. The balance of the jail time should be suspended. Okay. If that's what you understand, Mr. Haddad, that's,
Yes, it's the balance of suspended.
okay.
So there's no additional, jail time, Judge, and the only condition is that she stays away, the balance is suspended, staying away from that, location.
Okay, Ms. Grace, are we clear for the paperwork on that?
Balance suspended, 180 days and stay away from the Greyhound bus station. Is that correct?
Yes, the jail time is suspended.
Mhm. Yes, sir, I have it.
Okay, just wanted to make sure. All right,
Thank you.
anything further? Yes.
Okay.
All right, good morning, Ms. Barber. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Judge Marlowe.
Thank you. Thank you, Ms. Barber. You can place your hand down. It's my understanding, ma'am, that in case 26 CR 001609F, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, I'm not.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, I already once before said not guilty. Yes, I agree with that, right?
Okay, has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Barber. Good luck to you, ma'am.
Thank you, sir.
Yes, ma'am.
Ladies, that's right. Come on, Bob. Thank you, Rhonda. Bye,
All
everybody.
right, see you next time.
Okay.
Who do we have next?
Position 26.7, Mr. Hammond.
It's a negotiated plea, Judge.
Thank you. Good morning, Mr. Hammond. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Say it again for me. Okay, thank you. You can place your hand down. Yes, Ms. Evans Bradley.
There is a, I don't know, did you get a revised amount for the restitution on Mr. Hammond's case?
No, I got nothing about Mr. Hammond other than what was on the initial offer.
Okay. Well, I'll just advise that, okay, as to the first case, then, the 1735G, it's 12 months served, 40 days, credit for time served, balance probated, complete an anti-theft course, fine in the amount of $250, no further contact with Jensen Star, STAHR. The victim in this case has submitted to us a receipt regarding the damages for the scooter, asking for an amount of $869.
I'll need to speak with him, Judge. I mean, this is significantly.
Yes, it's a significant amount of difference. I thought I sent an email over, it was late yesterday when I received the information. But okay. Do you want me to send you the receipt?
That'd be helpful. Thank you.
Okay,
And then I can just.
all right then.
Do you guys want me to call him or you want to call me?
You can call.
Okay, thanks.
Yes, in the meantime, we'll do the two probations that we can do that.
Okay, and Mr. Haddad, what are we gonna do with position 51, Shamar Walker?
It's gonna be a waiver, Judge, not guilty.
Okay, thank you.
And Your Honor, on the probation violation, I mean, I don't have a recommendation. I mean, if it's time served, we can close it out now. If anything else, we don't have the petition.
Good morning, Your Honor. Ms. Allen on behalf of probation.
Yes, good morning, Ms. Allen.
Which position are we talking about? Which defendant?
Either Andre Hill or Travis Butt.
Okay, Your Honor, as far as Andre Hill, Your Honor, I will be asking for his case to be time served. He has now been in custody since April 10th, and there was only 12 days remaining on his case.
So we gotta close out the probation. And that's fine, Judge. We can close it out, Judge.
Okay, good morning, Mr. Hill. This is the probation revocation calendar. I'll accept the recommendation from probation, time served. Good luck to you, sir.
Thank you, sir.
Yes, sir. This is Mr. Butts. Is that right?
Yes, sir.
Yes, Judge.
Okay, all right. Yes, good morning, Mr. Butts. Again, I'm Judge Eric Morrow. This is the probation revocation calendar. Yes, Officer Allen. You're on mute there.
Sorry. Mr. Butts has been in custody now since March the 30th of this year, Your Honor, but it is 262 days remaining on Mr. Butts' case. He was required to complete a shoplifting course as well as 40 hours of community service. Your Honor, at this time, I will be asking for Mr. Butts to be allowed to continue on probation to satisfy those conditions.
Just 1 second.
Okay.
That's acceptable, Judge. I had to explain to Mr. Butts and with instructions that he has to put to probation, Ms. Allen, by what day?
24 hours upon release. It doesn't look like he's in custody for any other charges. Also, let me add, because I just realized he also has a fine, Your Honor. Being that he has been in custody since March the 30th, I will be asking for that fine to be suspended so he can complete the 40 hours in the shoplifting course.
Thank you. Thank you, Ms. Allen. Thank you, Judge.
Okay, yes, I'll accept that recommendation, Officer Allen. Mr. Butts, go ahead and get this behind you so that you don't have to, you're not here again, okay? So I'll return you to probation to complete those requirements. Good luck to you, sir. Who do we have?
Going back to position. Yeah, go back 26, 27, Mr. Hammond.
And Judge, Mr. Hammond is, well, he contends he doesn't think the scooter was damaged. He is willing to go ahead and accept the additional element of restitution. We would ask in that regard that they were initially asking for a $250 fine, that we suspend that fine. He can, that way that money could be applied to the restitution and waive at least 6 months of probation fees.
That is fine. I still haven't found the receipt for you. I'll just send an email to the victim advocate because I know they sent it to me yesterday.
So, Ms. Evans Battle, what you're telling me is that the defense request is acceptable by the state.
Yes, Your Honor.
Okay. And so we've taken care of the theft by taking, I don't believe we've talked about position 27, the criminal trespass, Ms. Evans Battle.
Yes, Your Honor. 12 months served, 34 days credit for time served, balance suspended, and stay away from MARTA in compliance with any suspensions, bans that are already in place, and stipulate to identity, venue, and a factual basis for the plea.
And
Thank you.
Judge, we so stipulate, and again, just reiterate that we would ask for a fee waiver of 6 months.
Okay. Mr. Hammond, it's my understanding that in case 26 CR 001735G, you wish to plead guilty to theft by taking, and in case 26 CR 002413G, you wish to plead guilty to criminal trespass. Is that correct?
That's correct.
Are you under the influence of any drugs or alcohol at the present time?
Sure.
You've been represented by counsel. Are you satisfied with his representation?
I am.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
I do.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Hammond. I will waive 6 months of the probation fees to help you get on your feet. And when you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
How long is probation again? Sorry.
It'll be about,
Go ahead, Mr.
sorry.
White.
It'll be about 11 months.
Okay.
And Ms. Evans Batters, can I please get the restitution amount again?
$869.
Hey, another question, where would I sign up for probation? Like, where?
Thank you, Judge.
It's 132 Mitchell Street, it's over near the courthouse.
All right, this got 48, 49, Mr. Smithburg.
Judge, this will be a negotiated plea.
Good morning, Mr. Smithburg. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Say it again for me. You're gonna have to scooch up for me or speak louder. We're not catching him we're not catching him on that microphone.
Muted.
Good.
Yes, sir.
Okay, thank you, Mr. Smithburg. You can place your hand in. Yes, Miss Evans Battle.
Yes, that's count 1, 12 months served, 30 days, credit for time served, balance probated, complete an anti-theft course, no further contact with Sharma, Miller, Rejas, stay away from Ken Byers Tennis Complex at 960 Fowler Street Northwest, comply with any Georgia Tech suspensions or bans. As to count 2, 12 months probation, pay a fine in the amount of $300. And as to the FTA, the state would move to null pros that case as part of the plea.
Mr. White?
Your Honor, we do stipulate for the purposes of the plea. We would ask to convert the $300 fine to 30 hours of community service and waive the first 2 months of his probation fees and ask that his probation terminate once he completes all of his requirements.
Mr. Smithburg, it's my understanding that in case 24 CR 007313B, you wish to plead guilty to theft by taking and willful obstruction of law enforcement. Is that correct?
Yeah, I don't know what I said, but yeah, sure.
Well, it's up to you, Mr. Smithburg. If you wish to plead guilty,
I mean, I guess, yeah, I'm guilty, I guess.
well, I don't need an I guess, Mr. Smithburg. Either you do or you don't. So I'm happy to either have Mr. White speak more to you or or for you to enter a not guilty plea if that's what you choose to do.
So what are they saying I stole?
I'll call back, Judge, and talk to him.
Okay, thank you, Mr. White. We'll have someone speak with you, Mr. Smithburg.
Yeah, can I just plead guilty? You can't, but sure. Let me talk to him real quick. Okay.
Judge, I'll call him back.
Okay.
Okay.
Your Honor, may I address an issue that's not on the calendar?
Fine with me, Mr. Dodd.
Judge, there was I represented a Thomas Danley last Thursday, Judge. He got a time served sentence, and he was supposed to be released into the custody of somebody in a program the next morning. And Judge Williams, who was covering, signed that order. That person never came up to pick him up. Turns out she was in a car accident, and she's still at the hospital. So I'm going to present the court with an order to release the client who got time served to the custody of our social worker and investigator, so they can drive him to that program. That's and I forwarded to Ms. Grace is the mitigation manager. But I just want to give the court a background as to what transpired on this case.
Okay, well, given that Judge Williams signed that order, we can get that to Judge Williams with an explanation of what you're requesting, and get her to modify her order.
Thank you, Judge. And what I'll do is I'll put that email to Ms. Grace. I don't want to email, of course, Judge Williams directly. I'll forward it to Ms. Grace.
Okay, very good. Thank you.
Thank you, Judge. I'll follow this. Thank you.
Are we gonna have Michael Davis this morning on the probation calendar, courtroom 2?
So he is not here, Judge. As far as Mr. Davis, he was here separate on a different case where he entered a plea of not guilty. It's a division Judge Mather. So there's something else keeping him. We can reset the probation violation to next week, or whenever, or maybe it goes back to Judge Edie. So I'll leave that up to probation and the court, of course.
Your Honor, for Mr. Davis, can we reset him on this calendar, well, at the SAP calendar for next week? Because I'm not sure when we will be able to, Judge Edie will be able to hear the case.
Okay. So we'll reset positions 3 and 4, Michael Davis on the probation revocation calendar till next week.
Thank you. Thank you, Ms.
All
Allen.
right.
Thank you, Your Honor. That concludes my business, my big excuse.
Yes, have a good rest of your day.
Thank
Always
you.
good to see you.
Judge, we can go back to Mr. Smithburg.
Okay. So
We are.
Go ahead, Mr. White.
We're squared away now, Judge, and he's good to go.
Okay. So, Mr. Smithburg, you're still under oath. It's my understanding that in case 24 CR 007313B, you wish to plead guilty to theft by taking and willful obstruction of law enforcement. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Sure.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Smithburg. I will convert the $300 fine to 30 hours of community service. I'll waive 2 months of the probation fees to help you get on your feet. And when you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Thank you, Judge.
All right, now we're going to position number 8 and 9, Mr. Brown.
Hey, you got Mr. Brown right, Joe?
So what were we able to find out about Mr. Brown from last week?
Your Honor, so we had requested that there not be a stay away, and had lots of issues with the probation. And the state was attempting to get an administrator to determine whether or not he's welcome back at the center.
Your Honor, the note that was given to me was that you wanted to personally call the administrator.
Now, you know that would not be, that doesn't, Ms. Evans-Battle, you know, that doesn't even sound right, right?
So I didn't know if we were supposed to have been in a breakout room or whatever, and they just gave me the number and the administrator's name while I've been in court. And so I sent the email to you and Mr. White with the information. So I can ask the victim advocate to reach out to them. I know that they've spoken with Ms. Carter, and that's who they spoke with this morning to get the administrator's information. So I've not spoken to an administrator.
No, that's unfortunate because this case has been on my mind since last week because it's a difficult situation. Is he in custody on anything else besides these charges?
No, Judge.
And I would consider some type of bond modification if he does not have a signature bond on this matter. If that's something you'd like me to entertain, Mr. White.
We would be thrilled with a signature bond at this point. We would ask that it not have any stay away provision from that address. Now, if he's not allowed back, they can, and I'm not sure, just honestly, they would need to evict him if he's a resident of a place, like the same eviction process for somebody in an apartment or renting a home. I honestly don't know, but I mean, we would just prefer that there not be any stay away.
Well, I'm going to give him a one-time escort. If he's allowed back there, then he can stay. If not, he'll have to find someplace else to go. So can someone tell me what the current bond is for both of these charges, both of these matters?
So I have 1,000 surety on the simple battery and 2,000 surety on the other SB charge.
There's also the other case, position 8, disorderly conduct and false info.
Okay, and what is the current bond on those?
I don't have it broken down, Judge. I have a 6,000 total.
I can pull it up here. And so that is the case that is 2,000 surety on the disorderly conduct and 1,000 on the giving false information to officers. And he had a failure to appear on that case. I think that's the issue, is his failure to appear is not qualifying him.
And that's a 6-year-old case, Judge.
Okay, and that's not on the calendar though, right? The FTA?
The FTA is not on the calendar, no.
Okay. So, given my request last week and that we're not able to really proceed this week, I am going to, Mr. White, convert the surety bonds to signature bonds through pretrial level 1. So for position number 8, that will be a total of 3,000 SLB through pretrial level 1. He's to have all the same conditions as the previous bond. The FTA on that case, if you'll set that aside, given the date of that case. As far as position 9, I'll convert both of those to signature bonds as well. Yeah. He can, with the no further contact, I'll give him a one-time escort to the Pruitt Health Facility. If he's welcome back, he can stay. If not, he'll have to gather his belongings and find someplace else to stay.
Yes.
Judge, just to be clear, on position 8, do we need a bench warrant set aside or a bond order? I mean, yeah, set aside for the FTA set aside or a bond order? Or both?
Both.
I think we need both. I think we need a bond
Both?
order for
Got
the
it. Can do
two.
that.
Okay, and then a set aside for the FTA. Is that the
The bond
question?
order,
Correct.
right, yeah. Okay, so 2 bond orders, 1 set aside.
Yes, right.
Perfect. Okay.
Okay, all right, and his case will be I guess returned to the division judge
Your
as
own.
well. All right.
Excuse me, Judge.
Yes. Yes, Ms. Grace.
1,500 is the second case, 3,000 and 1,500 on each, the 8th, position 8 and position 9, 1,500 on each, totaling up
No.
to 2,000. How you breaking it
No,
down?
I think that what was recommended was the disorderly was 2,000, the giving false information is 1,000.
Okay,
Okay, and on the second, the simple battery is 1,000, the other charge is 2,000.
got it. Thank you.
Okay. All right, let's see. Are we going to see Tyquan McNeil today? Position 40 and 41?
Judge, I don't know. They were unable to locate him in the jail yesterday. I went to the floor that he was assigned to. They said he wasn't there and they were going to look for him. And apparently they couldn't find him this morning either. So
Do you want to reset him till, I mean, he has, I mean, it's a time served offer. Do you want to reset him till Thursday?
Judge, if we can find him, I don't know. I mean, if jail has any hope of finding him, but yes, as soon as possible, because he's also being held on no bond on the misdemeanors.
Yeah, they
Courtroom
can't,
2, go ahead.
I just spoke to deputies, they can't find him.
Guess we try again for Thursday. We can't blood from a stone and all.
Go back to school as hell.
Okay, so positions 40 and 41 will reset for Thursday, which is the 30th.
I'm not no more.
Okay, does that take care of everyone on the 9 o'clock calendar?
Yeah, Judge, can we, deputies asked if we can hold on McNeil. They're gonna try and see if they can find him.
Okay, that's fine.
Mr. Hirsch is here.
Yes, let's see. Let's move on to the bench warrant calendar. Good morning, Mr. Hirsch. You are representing James Page, is that right?
Jamel Page, Judge. It's in the his name is correct on the accusation. It is incorrect in the Odyssey.
Okay. So how do you spell his first name?
Jamel, Jamel.
Later tonight. Okay.
All right, and before I take that case, let me see who else is here so that I can, is Gerald Collins with me? Yes, Mr. Collins, I see you there. Mr. Collins, are you with me? All right, I'll move on to position 2.
Yes.
He's coming on now.
Okay. Mr. Collins, can you come on camera for me, sir?
Yes, we're here.
Okay, come on camera for me.
Do you see us?
Yes, I can see you now. Mr. Collins, can you go ahead and place your phone number into, or Mr. White, do you want to go in a breakout room?
Yeah, that's probably the easiest, Judge, if we can just do a breakout room, Mr. Collins.
Okay, so I'm going to place you. This is Attorney White here. I'm going to place you all into a breakout room so you can discuss your case with him, Mr. Collins.
Okay,
All
do I have
right,
to mention,
so
if I have to press anything?
something will come up on your screen. Ms. Strong, can you place those them into a breakout room for me?
Yes, sir.
Can someone send me the DV calendar? Please.
And let's see, Miss Jessica, can you come on camera for me? Jessica Martin. Yes, ma'am. Can you place your phone number in the chat for the court so we can have someone call you?
Okay.
All right, thank you, ma'am. And Deshawnette Walker. Miss Walker, can you come on camera for me? And Miss Walker, can you place your number in the chat as well so we can have someone call you? Miss Walker, did you hear the request? Just want to make sure. Miss Walker, can you speak to me? I can't hear you. I still can't, something's, we still can't hear you, Miss Walker. You may need to log out and log back in and accept audio when you come back to us. I'll make note that you're here, okay? But go ahead and place your number. Well, no, let's see if we can hear you first. All right, Ms. Evans Battle, have you gotten that calendar?
Yes, Your Honor.
Okay, so let's go to Mr. Page. Good morning, Mr. Page. I'm Judge Eric Morrow. This is the DV bench warrant calendar. I take it, Ms. Evans Battle, that Mr. Page missed the court date?
Yes, Your Honor.
Judge, his original arraignment was back in 2019. He was in DOJ custody at the time. When he got out, he did do a change of address. You can see that in Odyssey, but he never received notice for a subsequent plea and arraignment in March. And I'm not sure what happened with that notice. He's been living at the same address that he filed the change of address, that is on the filed change of address. And so it wasn't out of any sort of not wanting to be present, Judge. He didn't know about it. And but we're here now.
Let me make sure that I have the proper address in the system. Ms. Evans Battle, can you tell me where the notice was sent?
Yes, we're having a storm. I'm really struggling with Odyssey.
1371 Kimberly Way, apartment 118-103, Atlanta.
Is that correct, Mr. Page? Turn on your mic. Your mic's off.
Oh, I'm sorry.
Can you hear me
I
now?
apologize. I
Yes.
apologize. No, that's what the updated one. It's 3250 Oakley Place is where it was sent. My apologies.
Okay, and what is his correct address?
Jamel, what's your current address?
Oh, I'm sorry, 1371 Kimberly Way.
Okay, and
Apartment, that's Atlanta.
apartment,
18103.
is that what we have, Ms. Strong?
Yes, sir.
All right, thank you. So, Mr. Hirsch and Mr. Page, it's my practice that I will set aside on one occasion. If he misses court again, it won't be set aside, but we'll go ahead and set this one aside. You'll get notice of your next hearing date. Mr. Hirsch, I take it that you are attorney of record on the matter, so
Yes,
you
sir.
should be notified as well. So, and normally, Mr. Hirsch, I have the attorney prepare the set aside order for me. So if you can get that to Miss Grace, she'll get it to me, and we'll get it signed.
Yes, sir. We'll do that.
All right.
I have her email address. Do. Oh, maybe I don't. I'll get it, Judge. I'll get you the order.
Okay, very good. If nothing further, you all are free to go this morning. Enjoy the rest of your day.
Thank you, Judge. You too.
Thank
Bye-bye.
you.
Bye-bye.
So we have, let me just go ahead and get you, Mr. Haddad, have you had the opportunity to speak with either of these other individuals that's on the calendar?
No, Judge, but I am ready to proceed with the plea on Mr. McNeil. So I ended up speaking to Ms. White.
Oh, thank you. And I guess I'm done with,
Okay, so why don't we go, Miss Jessica there? I'm going to place you into a breakout room with Mr. White. Okay, so go ahead and unmute yourself so that you can speak with him when you get there. All right, thank you, ma'am.
Judge, does the paperwork need to go to Ms. Grace today? I missed the memo.
Yes, yes, it goes to Miss Grace.
Thank you, Judge.
Let's see, so this is position 40 and 41, Mr. McNeil.
Yes.
And tell me again, Mr. Dot, what are we doing with Mr. McNeil?
It's going to be negotiated with the judge as stated in the calendar that recommended.
Okay. Good morning, Mr. McNeil. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Thank you. You can place your hand down. Yes, Ms. Evans-Bannell.
Yes, as to count one is 12 months served, 24 days credit for time served, balance probated, show proof of anger awareness completion, 3 parenting classes, no further contact with Dominique Buford and the minor child. As to the criminal trespass, count 2, 12 months probation, restitution for the door. I'd ask for 30 days in order to get the amount of the restitution. And as to count 3, 12 months, was a restitution for a laptop to Dominique Buford and no further contact with her and the minor child. I would ask for 30 days for restitution. Stipulate to identity, venue, and factual basis for the plea. Thank you.
Mr. Haddad?
Judge, we shall stipulate.
Nothing further. Mr. McNeil, it's my understanding that in case 25 CR 002052J, you wish to plead guilty to simple battery, family violence, and 2 counts of criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Sure.
You've been represented by counsel. Are you satisfied with his representation?
Sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. McNeil. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Okay, sir.
Okay, that's it. You'll be released later tonight, okay?
Okay, yes, sir.
Thank you. And probation is.
Okay.
Mitchell.
You write it down, yes, sir.
And Mr. Haddad,
Yes, Judge.
when you get a chance, Ms. Walker's number is in the chat. If you wouldn't mind giving her a call or having her call us, you.
I'll take care of it, Judge.
Thank you. And is there something further, Mr. Hirsch?
No, sir. I just discovered that I actually do need Miss Grace's email address.
Okay. Ms. Grace, if you wouldn't, if it's not already in the chat, would you place, I believe it might already be in the chat.
It should, but with him coming on late.
It was, but
Oh, okay.
I need it in.
Okay.
Sorry.
Okay, let's see. Mr. Collins,
Yes.
come on camera for me, please, sir. Okay, good morning again, Mr. Collins. I'm Judge Eric Morrow. This is the DV bench warrant calendar. Ms. Evans Battle, I take it that Mr. Collins missed the court date?
No.
Yeah.
I never got into the come to court.
Okay, hold on, Mr. Collins. Let Mr. White speak for you, okay?
We have a March the 28th of 2024 was the first court date. And then yeah, that's the date that we have that he missed the court date. There was a return to sender on May the 9th of 2024. And the address that went to was the 500 McDaniel Street, apartment 1392 in Atlanta.
I have yes, Judge. I'm sorry. So this is my understanding is the first time he's missed court. It is an older case, as you've heard. And he had no idea that he had missed a court date. In fact, they were under the impression, I've spoken with his mother as well, that the case wasn't going to be going forward. Obviously, that's not the case, and we're straightened out there. But I do have a different address. It's 765 McDaniel Street, apartment 1120. That's Atlanta 30310.
Okay, were we able to get that, Ms. Strong?
Yes, sir. That's what we have in the system.
Okay, very good. So Mr. Collins, it's my practice to set aside the first time that you missed court. Apparently, it was returned to sender. I'm going to request that you make sure that you stay in touch with the court so that you don't miss any further court dates. But we'll set this one aside, okay?
Okay. Yes, sir.
All right.
What I got a question. I can answer the question.
Okay.
What about the warrant?
That it's being set aside. The warrant is going away. That's what this is.
Okay.
Yeah.
Okay. Any other questions, Mr. Collins?
No.
All right. You're free to go this morning. Good luck to you, sir.
Okay, thank you.
And let's see, Miss Jessica Martin there. Can you come back on? Yes, ma'am. Good morning again. I'm Judge Eric Morrow. This is the DV bench warrant calendar. Ms. Evans Bell, I take it that court date was missed?
Yes, Your Honor. She missed a court date back in April. Looks like April the 14th of this year. She failed to appear. I don't have a return to sender here. I do have a notice that was sent to her. Notice was sent to her on March the 9th of 2026 to 3103 Lakefield Place, Johns Creek, Georgia, 30097.
And she doesn't reside there anymore, Your Honor. She has subsequently changed her address when she realized she missed this court date. She was unaware that she needed to do it with the court specifically. I've explained to her that going forward, also how to follow on the website and or calling the clerk's office. So my understanding it's her first time.
What's the proper address?
I believe she's already given it to pretrial. I'm sorry, not pretrial, to the clerk's office when she got this scheduled.
Ms. Strong, do we have her address?
Is it the Anderson, South Carolina address? Yes, sir, we have it.
Okay, thank you. So ma'am, I'll set this one aside on this occasion. Please don't miss another court date. If so, it won't be set aside the next time. Okay, you need to make sure you stay in touch with the court if you move.
Yes, sir.
All right. So you are free to go this morning. Enjoy the rest of your day.
Thank you. You said.
Thank you, ma'am. And Mr. Haddad, were you able to speak with Ms. Walker?
Yes, Judge, and we're ready to proceed.
Okay, Ms. Walker, are you with me? Okay, so we still can't, can you speak, ma'am? We still can't hear you, Ms. Walker. Can you hear us? Can you hear me, Ms. Walker? If you can, nod your head. Okay. And you've spoken with her, Mr. Dodd?
Yes, Judge, and I can, as long as she hears, I think.
Okay.
Judge.
All right. So Ms. Evans Bell, I take it that Ms. Walker missed the court date?
Yeah, she missed the April the 14th of 2026 court date. There appears to be a notice that was mailed to her on March the 9th of 2026. And that calendar noted that her address was 1336 Willow Trail, Southwest Atlanta. I also see in the file a bond forfeiture set aside in here as well. That was issued April the 22nd of 2026. I don't know if that's for this court. It looks like that they already, it looks like this was already set aside.
It's not set aside, it's still a warrant in the system, Ms. Walker.
Okay, so the ones that are, it says it's a bench warrant withdrawal from April the 22nd of 2026 that are in here are not correct.
If they did do it, they didn't take the warrant out of the system, so she still has an active warrant.
Okay.
And it's nothing in Odyssey stating that the case was set aside. It just shows that she was reset for this calendar here.
Okay.
Okay, thank you, Ms. Evans. Ms. Walker, you're gonna have to stay on camera for me. Thank you. Mr. Dodd?
Judge, spoke to Ms. Walker. She did confirm that is her address. She says she never received the notice. She also went back, she signed up for the USPS digital service. She went back through and she never received any digital notification either. She had been reporting to pretrial services. And so as soon as she was notified by pretrial what's going on, she went back to the courthouse and got this notice. And also, I think filled out another sheet for the same information. That is her address, Judge. So I've asked her to be a little bit more proactive in terms of looking up on the computer, make sure that just in the event that she does not receive notice, at least she's aware of the court date, which is often published on online.
Okay. So Ms. Walker, I will set aside this bench warrant. Please keep in touch with the court to make sure that you don't miss any other court dates, okay? If you'll nod for me that you heard me. Okay, thank you, ma'am. So if you'll prepare that for me, Mr. Dodd, we'll get it signed.
I'll take care of it, Judge.
Joanne, if you want me to, I can do that one.
Oh, that'd be even better, Mr. White. Thank you.
No worries.
All right, you're free to go, Ms. Walker. All right, I believe that completes the calendars for this morning. Ms. Grace, whenever you're ready to go over the calendars.
Yes, sir. Position number 1 was a plea. Position number 2 was a plea. Position number 3, I need the correct reset date.
I believe June 8th, Tuesday.
Oh, June 8th?
Yep, 6/8.
So it would be 6/9. That's a Monday.
Oh, sorry about that.
That's okay. Position number 3 and 4 reset June the 9th. SAP calendar. Position number 5 and 6 were pleas. Position 7, non-pros. Position 8 was an amended bond order, 3,000 pretrial 1. Position 9, amended bond order, pretrial 3,000. Position 10 was a plea. Position 11, non-pros. Position 12 and 13, reset jail jury. Position 14, reset jail jury. Position 15 and 16 were pleas. Position 17, non-pros. Position 18, reset jail jury, along with position 19. Position 20 and 21, reset May the 12th, SAP. Position 22 was a non-pros. Position 23 and 24 were pleas. Position 25, reset jail jury. Position 26 and 27 were pleas. Position 28, 29, 30, and 31, reset further notice, defendant relief. Position 32 was a plea. Position 33 was non-pros. Position 34 was non-pros. Position 35, reset 5/5/26 SAP. Position 36 was a plea. Position 37, 38 were plea. Position 39, reset jail jury. Position 40 was a plea. Position 41 was non-pros. Position 42 was a plea. Position 43 non-pros. Position 44 and 45 reset 5/12 SAP. Position 46 was a plea. along with the additional case, and position 47 was non-pros. Position 48 was a plea, position 49 non-pros. Position 50 was a plea, position 51 reset jail jury, position 52 reset jail jury, position 53 was a plea, position 54 reset 5/9/19 SAP, position 55 and 56 were pleas, position 57 and 58 are non-pros. Any questions, comments, or concerns?
Nothing here.
And all of the bench warrant, the DV calendar, keep that further notice.
Okay, if nothing further, thank you all. Have a good rest of your day. We will see you next Tuesday.
Ms. Evans,
Thank you.
Saddle,
Thank you.
did you see my chat?
Yes, I responded.
Oh, you did?
I did. She is asking about Mr. McNeil. He, under his bond condition, he was supposed to complete anger management classes. So that was part of his order, was either show proof or complete them.
So if he shows proof, he don't have to take the class again.
Correct, because there's no need for him to do it twice.
Okay, we all clear? All right, we'll see you
All right.
next time. Y'all have a
Thank
good
you.
day.
Bye.